Okay, the next case on the docket is South Investment versus Icon Investment.
Good morning.
Morning.
May it please the court, I'd like to reserve 5 minutes for rebuttal as well.
Okay.
This is a tax deed case. Lower court awarded the property back to the corporate owner based on summary judgment. We have 2 issues that we brought before the court. The first dealt with the statutory requirement that no tax deed sale be held prior to 30 days before the first notice of publication. We argued to the lower court that this was directory only and not jurisdictional. The court found, I think, that it was jurisdictional and entered summary judgment on that basis. Our reason for saying that this is directory only falls back on several items. The first being that there was a change in the statute, this particular statute in 1973. The statute prior to this said that no tax deed shall be issued, and that changed to no tax deed sale shall be held. Now, I understand the use of the word shall, that implies that there shall not be a tax deed sale if there is not this 30-day publication requirement. But I think if you look at other instances in that tax deed statute where the word shall is used, you'll agree that other courts have said, well, it says shall, but we're still going to say it's directory. The first example would be in 197.5222, which requires a sheriff to notify the person by service of the impending tax deed sale. The statute does say that the sheriff shall do that. But in Dawson versus Seda, the Supreme Court said that it says shall, but we find that that is only directory only. The main requirement we're concerned about is whether or not the standards in 522.1 are met, which is the notice by certified mail. In addition, as a court many years ago, Supreme Court found the statute used to say that the notice of publication shall be filed with the court or the clerk on or prior to the date of sale. And the statute also referred to there that no tax deed shall issue. That law changed in 1941, I believe, to not require the no tax deed shall be issued. And again, in a case decided in the Saunders case versus Gilliam, the Supreme Court in that case approved of a dissent by Judge Wigington in the Gilliam case, where he said that when the legislature changed the statute, that caused it to be directory only. And he noticed that there was a trend in courts to not have this specific requirement of matching every single procedural step, and if you don't match it, the tax deed sale is invalid. They started to get away from that and relied mainly on the notice requirement that's in 522.1. I should also point out in that regard that there is a case, the Crane versus Martin case, the first DCA case, where the court found in that case that the publication was directory. In that case, it did not involve the failure to do it within the 30 days. In that case, actually, the clerk failed to put the name of the title holder on the publication. And in that case, the first DCA found that was a directory requirement only and not jurisdictional, something that was definitely
Is it
required.
your basic argument that that 197.5221 is the absolute requirement that the clerk has to comply with, and if the clerk complies with that requirement, everything else, including in subparagraph 2 and including 197, I think it's 512, is just basically additional steps that the clerk can take that aren't mandatory, but basically discretionary on the clerk's part? Is that your basic argument?
That's the basic argument, but I think there have been Supreme Court cases in Florida and the United States Supreme Court that have now changed that standard as to 522.1. I think now, after the Delta case, you have to look at the last assessed tax roll, the most recent one, not the one that the tax collector looks at gets its information from, and then sends to the clerk. And then after Vocilla, you have to also look to see if there's been any changes in addresses. If you've done that under 522.1, I think that you've met the statutory requirements. Now, the Jones case...
But in this particular case, there were signatures on the certified return receipts that really weren't signatures of, or that were purportedly not signatures of anybody connected with the owner of the property. Isn't that basically right? And that's uncontested, isn't it?
That's uncontested, but we know that now.
Okay, and when that happens, then what is the clerk's responsibility?
Well, this happened, I think, in the Vocilla case, where they mentioned that there were return receipts and that the clerk should have seen that those were not the signatures of the actual, persons they were addressed to. We have a different situation here. In this situation, the owner is a corporation. So I think it's expected that when a return receipt comes back from a corporation, it could have any number of signatures on it that could be, realistically, people authorized to sign that on behalf of the corporation. It could be a secretary. I mean, the clerk doesn't know that when it gets these back. All it knows is it's got a return receipt signed as to 2 of the units for this corporation. Realistically, the clerk did not have to do anything else, in my opinion, after that point as to those 2 units, because that was satisfied. They met that standard in 522.1. Now, as to the other unit, which is unit 405, the return receipt came back attempted not known. But the clerk did do something else in that regard, and I think this is actually something that's approved in the Jones case and also in the Cusack case, which was cited by the appellees in their brief, that posting is sufficient, may be sufficient, to establish notice.
Jones was a single-family residence, wasn't it?
Yes, it was.
Right. Well, here you have condo units.
Yes.
Jones talks about really what needs to be done in the context of the facts known at the time that these actions are taken, and it can differ from case to case, correct?
That's correct.
And do you think that there's a distinction between what you do with the single-family residence and what you do with a multi-unit condominium?
I don't think there's a distinction. I think that the standard would be the same, but I think there's a difference when it comes to getting a return receipt back. I think whether it's a corporation or a person, or whether it's commercial or residential, the standard, I think, is the same. Nobody can be deprived of their property without the proper, sufficient constitutional notice. And in this particular...
You're talking due process.
Yes, due process. And in this particular case, based upon Jones, the clerk does not have to do more until those return receipts come back as unclaimed. I mean, we have the Dawson case here that says if the clerk complies with this, then that meets this subsection 1 of 522, then that is sufficient to satisfy the notice requirements under Florida. That standard was, I think, eroded a little bit in the Delta property cases where it took them many months to actually get the notice sent out, and in that time the tax rule had changed, and a different address, I think in that case a different property owner was actually on there. And then it changed a little bit more when the Vocilla case came out, because there was a change of address that was sent in. We don't have that in this case. In this case, the property owner, the corporation, didn't send in any changes of addresses. I think that based upon that, you kind of have to look at those cases, the Bozeman, the Kidder, the Evans case, which are actually referred to in the Vocilla case. And in the Vocilla case, the court actually says these may be treated differently because the individual or the corporation here took no effort, to notify the clerk of a change of address. But in Vocilla, the person did. But we don't have that here. The address was set forth in the deed as the 8129 Sandpoint Boulevard. The corporation moved 2 or 3 times after that, never notified the clerk of any changes of address. The corporation thought when it was paying its mortgage that the mortgage company was actually paying the taxes, but that turned out not to be the case. The mortgage actually has the address where notice are to be sent. So that address was always there. The clerk sent out its notices to that address. That complies with 197.522(1). 2 of those notices came back showing they had been signed for. The clerk doesn't have to do anything else at that point. The clerk did something else. Not only did it send the sheriff out to all 3 addresses at the 81 Sandpoint and had them posted there, but also tried to serve them, and I think the Orange County clerk testified in deposition, they do this routinely, also sent notices to the actual property physical address, which was on Sand Lake Road, 7345 Sand Lake Road. And in that particular case, those notices showed that there were problems. The problems would be, as to the notices, they came back insufficient address. I think that's what all three of them came back as. The sheriff was sent out to there and tried to serve there as well. On two of the attempts by the sheriff, they found that they needed a suite number. Even though the actual notice had the unit number on it, the sheriff didn't take the next step to try to do that. And on one of them, the sheriff noted that, and this is, I think, as to 405, Unit 405, the sheriff noted that the actual, there's a 4-story condominium building here. I've looked on the marquee, and the corporate name isn't there on the marquee, and the address is not sufficient. But all that, I think, is irrelevant. These are just additional things. That the clerk getting those back should have been notified that, oh, I have to do something else to get it to that address, because the clerk already had complied with the statutory requirements by sending everything to 8129 Sand Point, which was the last address that the corporate owner had said, I'm to be notified at, and that was the last address on the assessed, most recent assessed roll.
Did the return receipt for the, I think it's 403, the one that they're claiming, you know, the sale was held 2 days early, did that return receipt come back unclaimed, or was there a signature on that one too?
I think that was 405. That one did
405,
come
right.
back unclaimed.
Okay.
But as I said, the clerk did send the sheriff out there, and the sheriff posted at that time. Counsel for the appellee may argue that the clerk should go beyond what's in its own records, should go, in this case, they argue that you should go look at sunbiz.org for the corporation and get the information about the corporation. The clerk testified that they found that information to be often unreliable, and they don't do that as a standard practice. Indeed, if you take a look at this court's decision in Greentree and also the Jones versus Flower case, the court there stated that they don't think the clerk has to go to the phone book. The clerk doesn't have to go beyond its own records and do a full search of all public records to get the right address for the party. And as to the 30 days, I would again reference, I think that is really directory. The fact is that nobody gets, no property owner really finds out about it through the publication. That's there for the bidders to get people to show up and bid at these sales. And I think that we're looking at it, instead of 30 days, it was 28 days. And I'd just like to refer the court to something Justice Peterson said in this court in the Hutchison case, when he's talking about whether the legal description on a particular item was sufficient in the tax deed sale, and he said that it was close enough for government work. And I think that when you're looking at 30 days versus 28, the notice was still sent out there. The difference, I think, is fairly immaterial. The notice was sent or published. And I think that the lack of 2 days there it shouldn't be sufficient to set aside the whole sale, especially when you got cases like Dawson and even Vocilla, which say that just because the person doesn't get notice doesn't mean the tax deed sale is invalid.
May it please the court, my name is Matthew Brenner. I represent the appellee, the plaintiff below, Icon Investments, LLC. In the courtroom today is my client, the sole member, Scott James, whose deposition was part of the...
Mr. Brenner, let me ask you a couple questions about the fact that the notices, the certified mail was sent to the last known address that the clerk had. 2 of them were signed for and 1 was not.
That is correct.
Is that correct? And the evidence, the record indicates that there's no evidence that there was any attempt to, on the part of your client, to notify the clerk's office of any change of address.
That is correct.
That's what the record states, right?
Yes, sir. The record states as the appellant properly noted that at his deposition that he was under the impression his
Right. He
his
thought,
taxes were being escrowed.
the mortgage holder was going to actually pay it.
That is correct, and what
So
the...
here's my question to you. It appears as though 197.522, subparagraph 1, was complied with, other than the fact that one of the notices came back and it was unclaimed.
50...
What then does, my question to you is, what then does subparagraph 1D mean when it says, "The failure of anyone to receive notices provided herein shall not affect the validity of the tax deed issued pursuant to the notice"?
Well, I think it means just what it says, as long as due process is complied with. I mean, that's what we're here about to discuss, is whether the controller's efforts were reasonably calculated under all the circumstances of this case, which includes a commercial 4-story condominium building, to give notice to the appellee of the tax sale. So I'm not disputing that that's... I'm sorry.
Why wasn't due process complied with here when the clerk sent the notice to the last known address and they didn't make any effort to notify them of the change of address?
Well, Judge, again, you have to look at the totality of the circumstances. As Jones said in Mullane, the United States Supreme Court decision, you must look at the particular and practicalities of each case. And in this case, the record clearly shows that the controller in Orange County not only tried to send notice to the last known address, but they...
Keep saying controller. Are we talking about the clerk of the court, or are you talking about Martha Haney, the comptroller?
It's actually, as I understand it from the deposition, it's Martha Haney's office that controls these tax sales. Carol Fogelsong is a sub-clerk for her. They do it on behalf of the clerk of court. It's a little different than a lot of counties in the state. But they not only sent it to the last known address as required by the statute, but they also took it upon themselves because, as Ms. Fogelsong stated, they take pride in trying to get redemptions. That's what they're all about. Mm-hmm. That's what the Jones v. Flowers case says. Success means redemption, not tax sales. And they went ahead and sent it to the property address. Now that, as Mr. Cathcart stated, that's extraneous. It's irrelevant. Once they send it to the last known address on the tax rolls, nothing else matters. I would submit that Jones v. Flowers and the other cases since Jones v. Flowers says quite the opposite. Once they undertook those efforts, they had the duty and burden to make sure those efforts succeeded in satisfying due process requirements.
And so what else did they do? They sent the sheriff out there to try and get service. They even posted it at the last known, I think it was at the Sandpoint address. Didn't they post it there?
Yes, sir. They posted at Sandpoint address.
And then in addition to that, they published it in the newspaper. Now, your complaint with that is that the tax sale was held 2 days early, but they did publish it in the newspaper as well.
As to two
What else
units.
was the clerk supposed to do?
Well, once the clerk received notice from the mailing to the property address saying suite number needed, address unknown, suite number needed on all 3 of those notices, and then also received the sheriff's return saying unserved to the property address now, not the last known address. Suite needed, can't serve these without the suite. In fact, as Mr. Cathcart stated, the one gave a complete description. This is a 4-story condo. We need a suite number to effectuate service. The clerk, according to her testimony, they just put that in a file. They don't really read those. They just put it in the file and make sure that it's properly done so they can make a check out to the sheriff. And I would submit that notwithstanding the extra effort they took, they should have looked at them and tried, as the Jones v. Flowers says, once the certified mail's returned, they should have made efforts to try to locate.
Doesn't the case law really say that it as long as due process is complied with, it doesn't matter whether they actually get it or not? And in this particular case, two of the return receipts has signatures on them. His argument is is the clerk supposed to know when you're sending this to a company that the signatures on the return receipt aren't people authorized by the company to receive the receipts? What's your reply to that?
Well, there's a couple of questions in there. In answer to your second question, I would submit to the court that the record before this court shows that they didn't even look at who the signature was, number one. They just put it, once they got a green card, they put it into their file and didn't think about it. But I don't think it's a stretch to ask the clerk of the court or the controller to determine whether that person is, in this instance, it's an LLC, sole member LLC. They could have certainly checked Sunbiz and determined whether the member or someone affiliated, registered agent, was the signatory of the contract and of the receipt notice. And the controller, Ms. Fogelsong, testified that she does use Sunbiz. What's interesting is Sunbiz is used after the sale occurred, when she's trying to find the location of a person to give the overbid to. So I would submit that that's a little backwards if you're trying to...
Isn't there case law, I think perhaps from the United States Supreme Court, that says it's just too much to ask the clerk to look these addresses up? I mean, it seems to me there's some responsibility on the owner to notify the clerk's office of a change of address. If they don't do that, then perhaps they take their own risk. But here the clerk sent everything to the last known address. 2 of the receipts came back, they were signed, 1 didn't. Then the clerk sends the sheriff out there to serve. The sheriff actually posts the notices at the last known address, and then in addition to that, the clerk's office publishes the notice in the newspaper.
Understood.
And so it doesn't the case law basically say that the clerk has done all that and the clerk has gone the last extra mile and due process has been satisfied, and then if the owner doesn't get the notice, then that's the owner's problem?
Well, Judge, I'm not sure the courts go that far to say that. I think the courts have said that it doesn't matter what the owners have done or have not done. Particularly Jones v. Flowers says this. It's really up to the state to make sure that they give proper notice. Now, I understand the court's argument saying what more could the clerk do, but I would submit, just as we've argued in our briefs, the clerk could have done more. The controller's office could have done more, and they were put on notice that there was a problem with this address they gave for the property address. Again, I'm not saying that...
Let me ask you this. Had the 30-day time limit been complied with after the notice in the newspaper had been, had been published, and they had actually waited instead of 28 days beyond the 30 days to hold the tax sale, would you still have a valid complaint about due process here?
Absolutely. As to that unit, the 505,
As to all 3 of them?
Well, the 2 of the units, there was no problem with the timing of the publication. That argument only relates to the 505.
Okay, well, let's go to the one that it does apply to.
That, we would still have a problem, yes, because that one is a clear Jones v. Flower situation, because that certified mail came back unreturned, and the clerk did nothing more after that. They just put it in their file according to the record.
Well, they sent the sheriff out, and the sheriff did publish it at the last known address, and in addition to that, they put the publication in the newspapers. My question to you is that I think the courts have clearly held that publication in the newspaper is not jurisdictional anymore. That statute is basically directory, and if the clerk complies with it, fine. If they don't, that doesn't necessarily invalidate the tax deed. My question to you is, if that's the case, why would it invalidate the tax deed if they complied with the notice requirement, put it in the newspaper, and held the tax sale only 2 days early?
I would submit, Judge, that the courts really haven't said that the publication issue is directory. The case is cited by...
Doesn't Crane say that?
Crane dealt with the substance of the notice. It didn't deal with the time frame involved with the notice. There are cases such as Stewart and Jernigan, which we've cited in our brief, which specifically says that's a jurisdictional issue, and it's for the benefit of the taxpayer to allow them to...
So you're saying that in addition to 197.5221, so paragraph 1, which the courts have specifically held is mandatory, that you're saying that in addition to that, 512 is also mandatory?
I'm saying that there's no case before this court that would say that it's not mandatory. I think the cases that exist in the state... What about the argument that, and this bothers me a little bit too, that the argument that really the notice is something that the clerk can do, and perhaps someone sometime may actually receive notice that their property is being sold, but it's basically for the benefit of bidders to come and bid on the property. And I can't bicker with that. There is case law that does say that. Either way, whether it's for the benefit of the taxpayer, which there are some cases that say it, or for the benefit of the clerk, so there's bidders that come, either way, it has a substantive impact on the rights of the appellee herein. Because if we didn't get notice, let's say for some lightning would strike and we saw it during that 2-day period, or alternatively, more bidders came and it would be a higher overbid, that's more money that would go into the pocket of the appellee. So either way, it's substantively affecting the rights, due process rights of the property owner. So I don't think that's really a distinction that needs to be concern this court.
In this case, they posted, which was one of the remedies or suggestions in the Flowers case. Why is that not sufficient to satisfy due process?
Judge, what's interesting in that whole issue is Jones v. Flowers did note that that would be a decent due process way around it by posting. What's interesting is Florida has said that's directive, so we sort of have an issue that may come up sometime in the future. But
Whether they did it. Whether it's directive or not directive.
That's correct. There's no question, there's no dispute on the record that they did post it. What I would submit, and what our whole argument was below and is here today, that while they did that at the last known address on the tax rolls, the clerk, the controller, bless their hearts, went more to try to find this owner. And when they did the extra effort and sent it to the property address, and then were given notice of problems with that property address, which they had the information right in their possession. Every one of the legal descriptions had the unit numbers in it. It specifically was there. It wouldn't have been a hard fix to try to, they didn't have to go to anywhere else but what was in front of them. They just needed to tell the sheriff, well, go get the unit number. Here's the unit number. It's on the tax rolls. It's on the records. Just here's the suite number to deliver it to. And then the record shows that had they delivered it, my client, Mr. James, and his company would have gotten notice of the tax sales. And that's for all three of them, but particularly, let's remember 505, they didn't even comply with the first part of the certified mail. They did post it, I can't deny that, that's the facts, but they didn't comply with doing more after the certified mail receipt was returned unclaimed, and Jones v. Flowers kicks in at that point. And I think just because it's posted doesn't mean that they shouldn't continue their efforts under the particular and practicalities of each case.
Do you think there's a difference between a single-family residence in Jones v. Flowers and condominium units?
I think there's a difference only to the extent that there was confusion in this instance. I mean, I think if this was a single, whether it's commercial or residential, if there was just a single unit, I don't think I'd be here arguing this case. I think Judge Adams would have ruled against me. But the fact is, the sheriff and the United States Postal Service told the clerk, we need a suite number. We need a suite number. We cannot serve this notice, which is required by the Constitution, on this property owner before we take their property until we get a suite number. The record shows the clerk, the controller, had the suite number in their possession from the beginning, from the first time the tax collector gave them the information. They had that number. It was called a unit number. But had that been on there, I would submit it is clear that we would have redeemed the property, paid the small amount of taxes that were involved, and we wouldn't have had a lawsuit. And I think at that point, if the suite number was provided, it would have been due process. It would have complied with Jones v. Flowers. It would have complied with the progeny since Jones v. Flowers. And I do submit, I understand the court's concern that my client made no attempts to give a change of address. But I don't think that's the issue the court needs to be focusing on after Jones v. Flowers and the Rosales decision. What the court needs to focus on is what does the state do?
Doesn't the case law basically say that once you get past 197.522, which is mandatory, the courts clearly hold that that's mandatory. Once the clerk gets past that and does these extra directory things to try and get notice, that basically what's important is the clerk attempts to do it, and if the clerk makes a mistake in one directory attempt as opposed to the others, that's not really what counts, because as the statute says, if the failure of anyone to actually get the notice really doesn't invalidate the tax sale. So isn't the important factor that the clerk makes the attempt to do it, and if they make a mistake along the way, that's...
Well, I think yes, and then we have to define what the attempt is, and you have Delta, and you have Jones v. Flowers.
Well, here we have the attempt to post. You're saying that, well, they didn't have the number, so that was wrong. And my question to you was, well, the clerk attempted to do it. Isn't that all that's required?
Well, no, I don't think it's all that's required. I think the court, as Jones v. Flowers and Ms. Fogelsholm testified, they want to find the people. They want redemption. That's success. And if they really wanted it, they wouldn't have, the controller wouldn't have just stuck things in the file. They would have read the sheriff's return. They would have read the United States Postal Service return, and they would have looked at their records. Oh, yeah, we do have a suite number here. So I think just because they attempt doesn't mean it automatically satisfies due process. I think before someone loses their property in this country and in this state, the clerk should do more. And I don't think the argument we made below and the argument we're making in this appeal is all that creates that much of a hardship for the clerk. Ms. Vogelsong testified that, again, she uses SunBiz, but she doesn't use it before the sale. She uses it to get rid of overbids. That seems to me, and she said twice in the record, that only takes 5 minutes to check SunBiz. It might not be reliable in all instances, but it only takes 5 minutes. Each of her clerks that work in this department have internet access at her desks. Now, I acknowledge, as the court has said, that some of the cases in Florida, and Jones v. Flowers even says you don't have to go to a phone book. But, these are modern times, and the internet has changed things. And I don't think we're on a limb asking this court to consider the fact that when you have a corporation, an LLC, or anything that would be with the Secretary of State's records, to spend 5 minutes or less to see whether or not a person from the corporation signed the green card, but even more so, just to find out where their address is. Maybe that will tell you the suite number of Sand Lake Road, or maybe it will tell you where they've moved to.
What profession is your client? Is your client a real estate broker?
The record reflects that, yes, he is a real estate broker. Correct. He holds a license.
And one of his defenses is that, well, he thought the holder of the mortgage was going to pay the taxes.
Well, that was his impression. I'm not sure the record reflects that he had a conversation with the mortgage company, but when he left that closing for the next 3 years, he spent a lot of money on these properties, and for the next 3 years he paid his mortgage religiously, never thought about taxes. This was a maelstrom. This whole case is as a result of a perfect storm, because he paid off his mortgage the same month that the application was made for the tax sale. So had he not paid off his mortgage and satisfied it, the mortgage company would have still been of record at the time of the notification, and the mortgage company would have gotten notice, would have immediately called its borrower or put the borrower on default for failure to pay taxes, and we wouldn't have this case. So it's just an unfortunate set of circumstances that I thought I'd share with you. It doesn't really shed any particular benefit, but I'm trying to answer your questions.
In their briefs, they kind of raise that to imply that it's kind of incredible that a person that buys and sells real estate as a profession who is a broker, number one, would think that the mortgage holder would pay the taxes, and number two, change his address without notifying the clerk. I mean, they kind of raise that to imply that that's kind of an incredible defense.
Judge, I understand that, and that may be true. However, I don't think that's what this court should be looking at. I think that's just not the issue. It's about due process and whether someone's property should be taken without doing that little extra. And in this case, it's clear from the record, and I think Judge Adams thought so, that this clerk was, as good a souls as they were trying to find him, they should have gone that extra yard. They should have done it. And the record shows that they do it after the sale to get rid of the extra money. I just don't understand why they couldn't have done it beforehand.
And why should they have done it?
Because success in these tax deeds, as testified to by the controller, and as noted in Jones v. Flowers, is trying to find the people, the owners, to get the taxes paid. It's not, they don't want to have sales. That was her testimony. They take pride in getting the taxes paid before sale. And that's what Jones v. Flowers notes as well, the United States Supreme Court. And
But they shouldn't have done it in this case because they were on notice that that the required statutory notice was defective. You don't have that argument in this case.
I do not. You're right, Your Honor. However, once they undertook the efforts based on Jones and Mullane, under all the circumstances that exist, they were on notice that they needed to do more to find this property owner.
I don't get that.
Well, okay. I'm sorry that I haven't explained it well. They will send it to the Sand Lake Road address.
They had no reason to believe that the required notice didn't make it.
Well, I would not go that far. I see I have 4 seconds left. May I answer the question?
Go ahead, sure, go ahead.
The green card, and I'm not saying this is our strongest argument, but it wasn't signed by the owner. It was signed by someone named Rodriguez. Nobody knows who that is. So potentially that would put them on notice. As to 505, they did not.
Well, clarify who the notice was sent to.
It was sent to Icon Investments at the Sandpoint.
It was sent to a company, a corporation.
That's correct, yes, sir.
Okay. All right.
Now, so they had that come back, and then for one of the units, the one that's the same subject of the 30-day issue, they got one. They didn't get a green card back. It was unknown. Need a addressee unknown. And then from their second mailing, and remember, the clerk signed a certificate, which is part of the tax deed process, which says we we attempted service at all these addresses, including Sandpoint and Sand Lake Road. And when they got those back, the green cards came back, insufficient address, need a suite number, and the sheriff's returns came back, need a suite number. It's a commercial office building. So based on that notification, the clerk, I would submit, it wouldn't have been hard, because they had the information from the beginning, to send out further notices or send the sheriff back out to the property address, and then to carry that further, the record reflects through the affidavit of the property manager that they would have found Mr. James. They would have found Icon, no problem, and we wouldn't have this argument today. I hope that's answered the question. Thank you, Your Honors.
Okay, thank you. You have 6 minutes and 34 seconds.
Mr. Cathcart, what were the amount of taxes involved here?
Your Honor, I don't recall. I would guess in the nature of, I think the property was purchased for $140,000, the 3 units, when the company first purchased them. And I'm sure it appreciated some, but I would guess, it had been 3 years since any had been paid, probably about $10,000 per property, somewhere in that range. But again, I think that's just a guess on my part. I think that the appellees put this additional burden on the clerk that's not warranted or supported by the case law. Appellee says that the clerk should look at Sunbiz. It's not that hard to do. The clerk should go ahead and do it. The appellee says the clerk should go beyond additional notices they send, which by the way, is permitted under 522(3) for the clerk to do more. And the record shows that Orange County does more all the time, and their record is pretty good as far as getting things redeemed. They I think, are one of the best counties in the state on that. But for the clerk to then be required to get notices back saying that the address is wrong at the additional address that they're sending it to, not the one that all the records show the company is located at, but at some other address that the actual property is at, they get something back saying it's wrong. They then have to now do something else to get the address right and resend it all.
What about Unit 405?
That's the unit that the green card came back as unclaimed, but again, we have the posting, the property was posted there. The notice was posted on that property. These are 3 different files. I mean, I'm guessing you're saying that, well, the clerk got 405 back as unclaimed, but got 403 and 404 back as claimed. Shouldn't that have raised something in the mind of the clerk? These are 3 different...
Oh, I'm just saying it as to 405 itself. 405 itself, they didn't get, they sent it there and they didn't get a return receipt. Something was wrong with 405.
Well, it came back as unclaimed. That doesn't mean that their person is not there. That just means they didn't claim it.
Right. Well, they've got no reason to believe that they've given, that notice has actually been received.
No, but as to 403 and 404, they did get a card back. But that they did go beyond that. They posted at that property. And that's the only address that was ever given to them as to where this company was located, that address. And I think that there should be more of a burden on the property owner to get the right address to the clerk. Pelley has said that the clerk should have seen the suite numbers were not on there, and the appellee should have given that information to the clerk. I think the burden is on them, and because of that, I think these other cases, the Hutchinson, the Evans versus Ireland cases, they're more appropriate to look at for this. The clerk made clear in its deposition it doesn't do addresses. It gets its addresses.
If the burden is on the owner of the property, why does the Supreme Court decide Jones v. Flowers in the manner that they do?
When a notice comes back unclaimed, Jones v. Flowers says the clerk must do something more. And they gave three examples. They say, we're not going to tell you how to do it, but we're going to give you 3 examples. One is to send one by regular mail to that address. Another one is to send one to the occupant, and a third one is to try posting. Now, those are the 3 things. Now, Jones v. Flowers came out after the sale in this case. The sale was in November of '05. Jones v. Flowers was April of '06. So the clerk didn't have the benefit of all that. The clerk just had to do what it had in the past. In this case, send the notice there. and to the property address and also to post it. And that's how they did it. Now, if the issue of publication wasn't so important, the cases all say, and even in Jones' case, they argued, well, we published. And the Supreme Court said, well, that doesn't matter. That's mainly for bidders, purchasers. We're not going to find that sufficient notice. And in my mind, when the court says that, the publication isn't all that big of a deal, I think that shows it's directory as opposed to jurisdictional. Thank you.
Thank you both.